In 1961, the United Nations adopted the Single Convention on Narcotic Drugs, which sets forth an evaluation and scheduling system through which the possession and distribution of specific categories of drugs are controlled. As a party to the Single Convention, the United States ratified the treaty in 1967. In 1970, while simultaneously declaring a war on drugs, Congress amended the Public Health Service Act to implement the Single Convention to carry out its obligations thereunder. Congress named the legislation the Comprehensive Drug Abuse Prevention and Control Act of 1970 before later renaming it to the Controlled Substances Act. Congress adopted the UN's drug schedules and a similar evaluation and scheduling process, while further creating criminal penalties for conduct prohibited under the convention, such as simple possession. A few months thereafter, the United States ratified the 1971 Convention on Psychotropic Substances. In 1978, Congress further amended the CSA to enact this convention into domestic law. The type of drugs subject to control under the CSA and conventions are limited to substances that affect the central nervous system, CNS drugs, and are identified as having a potential for abuse. Meaning under these laws, the government is only concerned with controlling possession of and access to substances that have the potential to affect our internal cognitive and emotional states. Once a substance is flagged as having the potential to affect those internal states, meaning it has potential for abuse, it then undergoes an evaluation to confirm said potential and to determine placement into one of 5 schedules. Once schedule placement is determined, the government proceeds with rulemaking to update the schedules, which are housed in the Code of Federal Regulations, and rely upon said schedules for its ongoing criminal enforcement actions. The CSA provides 2 separate sets of procedures for drug evaluation and scheduling. 1, procedures for drugs not scheduled by the UN under the conventions, whereby the respondents, which is the government here, perform their own evaluation and schedule placement decisions pursuant to required findings and factors set forth in the CSA. And 2, procedures for drugs evaluated and scheduled by the United Nations pursuant to the conventions, whereby respondents simply adopt and implement those decisions into the schedules without performing independent evaluations. Once a substance is added to the schedules, simple possession thereof is then criminalized accordingly. Respondents enforce the criminal provisions of the CSA in the same manner, regardless of whether the substance was evaluated and scheduled by the United Nations pursuant to the conventions or by the respondents.